Hello, thank you for attending this mini seminar on relationship breakdowns for teachers' pension plan members. This seminar is presented by the BC Teachers Federation. My name is Sarb Lally, and I'm the Assistant Director for Pensions and Group Benefits at the BC Teachers Federation. And I'm pleased to present this seminar from the unceded territories of the Squamish, Tsleil-Waututh, and Musqueam peoples. All right, let's start our seminar. For reference, today's date is July 20th, 2022. First of all, let's talk about the objectives. In this seminar, we're going to describe what can happen to your pension when you and your spouse separate or divorce. We have a disclaimer. The information in this presentation is not offered as legal advice. You should obtain advice from a qualified legal professional concerning the particular circumstances of your situation. So that's very important. Okay, so under the Family Law Act, people living together in a marriage-like relationship continuously for 2 years or more are considered to be spouses. And the pension is an asset that may be subject to division. So that's because pension is considered a type of family property. This means if a pension plan member separates or divorces, their former spouse or partner may be entitled to a portion of the member's pension. As the administrator of BC's Teachers Pension Plan, the BC Pension Corporation requires direction on whether to divide a pension and how to do it. The Family Law Act and Family Law Act Division of Pension Regulation provide a framework for dividing family property, including pensions. While Pension Corporation and the plans it administers cannot provide legal advice, what they can do is they can review any draft agreements and let you know if they can administer the division according to provincial law and plan rule requirements. Okay, so let's talk about a relationship breakdown and a limited member's rights. So former spouses may claim their share of a pension and become a limited member when the plan member reaches age 55, whether that plan member is retired or not. And their share of the pension is deposited directly into their account each month. So if you're a limited member, you're entitled to that share of the pension and it gets deposited into your account every month. If you don't become a limited member, your former spouse will receive the full pension and be responsible for forwarding your share to you. So you as the teacher, the plan member, if your former spouse doesn't become a limited member, then you as the teacher are responsible for forwarding your share of the pension to your former spouse. Now, with limited members, their estate automatically becomes their beneficiary. And if they get remarried, so if your former spouse gets remarried, they're not required to nominate their current spouse as a beneficiary. They can fill out the appropriate form from the teacher's pension plan and nominate anyone they want to be the beneficiary of their portion of your pension plan. And another important right that your former spouse has if they become a limited member is that they will receive a copy of your benefit statement each year. Okay, so what happens if you have a relationship breakdown before you retire? So your former spouse may apply to become a limited member, which allows their share of the pension to be paid directly to them when you turn 55 years old. If your spouse is not a limited member, but claims an interest in your pension, the pension corporation will contact them and give them 30 days to become a limited member. And then they may receive the pension as a monthly pension or a lump sum payment to a locked-in retirement vehicle. Okay, so that's for a relationship breakdown before you retire. What happens if your relationship breaks down after you've retired? So at this point, you're collecting your pension. At this point, you cannot choose a different pension option. Neither can your former spouse. Your former spouse may apply to become a limited member so that their share of the pension can be paid directly to them. And whatever pension option you chose when you retired will also apply to your former spouse. And depending on the pension option you chose when you retired, your former spouse may continue to receive their portion of the pension after your death. So what happens for a relationship breakdown and you die before you retire? So the standard provision under the Family Law Act is that your former spouse is entitled to 50% of the pension you earned during your relationship. But a separation agreement or court order may specify a different percentage. And to receive their share of your pension directly from the pension plan, your former spouse must apply to become a limited member of the plan within 30 days of receiving written notice from the pension corporation. Suppose your former spouse dies before you retire. So you're still a member of the teacher's pension plan and working and contributing at this time. So if your former spouse is a limited member and they die before you retire and before receiving their share of your pension, the pension is paid to their estate or beneficiary. Now, your former spouse can only name a beneficiary if they are a limited member. If they did not become a limited member before their death, their estate has 30 days from the date of the pension corporation's written notice to them to apply to become a limited member. What if your former spouse dies after you retire? And after your retirement, the separation occurs. So if you and your spouse separate after your retirement and your former spouse becomes a limited member, then you will receive their remaining share of your pension upon their death. And it will not go to your former spouse's beneficiary or estate. Okay, that's because the separation occurred after you retired. If the separation occurs before you retire, then if your former spouse died, the pension, their portion of the pension would go to their beneficiary or estate. Okay, so that's an important difference. How about if you have a new spousal relationship after you retire? So remember, the pension option you chose at retirement only applies to you and your former spouse. It doesn't apply to your new spouse. Your new spouse is not eligible for a pension benefit unless your former spouse waived their beneficiary rights when you started to receive your pension. And then you could nominate your new spouse as a beneficiary. And if you have a guarantee period and you die during the guarantee period, then your new spouse would be eligible to receive the remainder of your pension for that guarantee period. So what are the things that you need to do after separation? Well, you need to give the teacher's pension plan permission to share your information with a third party, such as a lawyer, because lawyers need to know what your pension is worth and then how that fits into all the assets that you have, and to then make an appropriate division of assets between you and your former spouse. You also need to let the teacher's pension plan know how to divide the pension. So that would be after your lawyers create an agreement, then they would send that to the teacher's pension plan to advise the teacher's pension plan about how to divide the pension. Have your former spouse apply to become a limited member, because that makes things much easier for you. You don't have to worry about having to forward their share of your pension to them directly. It can automatically be put into their bank account by the teacher's pension plan. Okay, once there's a separation, make sure you update your beneficiary information. You may choose someone else to be your beneficiary other than your former spouse. And you may need to update your name and contact information with the teacher's pension plan if your name and contact information have changed. Okay, let's look at a couple of scenarios. Scenario number one. Spouse one is 50 years old and has been a teacher in school district 36 for 25 years. They've been married to spouse two, a lawyer, for 10 years, during which time spouse one taught 1.0 FTE. They recently separated. So here are my questions. Do they have to split spouse one's pension equally? If they agree to split spouse one's pension equally, what will spouse two's share equal? What would spouse two's share be if spouse one taught 0.8 FTE during the marriage instead of 1.0 FTE? And finally, when can spouse two start collecting their share of spouse one's pension? All right, let's look at the answers. For question number one, do they have to split spouse one's pension equally? No, they do not. Now, the standard division under the Family Law Act is 50%, but you can have a court order or a separation agreement that changes that division from the standard 50% to a different percentage. However, if they do agree to split spouse one's pension equally, what will be spouse two's share? Well, it'll be 5 years of pensionable service, because remember, they were married for 10 years. And if it's a 50% division, spouse two is entitled to 50% of that 10 years of pensionable service. Ergo, 5 years of pensionable service. And likewise, what would spouse two's share be if spouse one taught 0.8 FTE during the marriage? Well, that would give you 4 years of pensionable service, because 0.8 FTE times 10 years equals 8 years of pensionable service. Divide that in half, and that's 4 years of pensionable service for spouse two. And the final question, when can spouse two start collecting their share of spouse one's pension? As soon as spouse one turns 55. So if they split up before spouse one turned 55, then as soon as spouse one turns 55, spouse two can start collecting their share of the pension. Spouse two could wait until spouse one turns 60 or starts collecting the pension themselves before getting their share, because that would be like a deferred pension. It would stay in the teacher's pension plan, and the money would continue to be invested, and it would continue to grow and build a pension benefit for spouse two. Okay, scenario number 2. Spouse 1 and spouse 2 are both teachers in school district 39 and are separating after being together for 10 years. Spouse 1 has taught for all 10 years and spouse 2 taught for 7 years during that period of time. My questions. If they decide to split their pensions equally, why might each spouse become a limited member to the other's pension? And question 2, should they split their pensions equally? Okay, let's go to question 1. So if they decide to split their pensions equally, why might each spouse become a limited member to the other's pension? Well, when each turns 55, the other will be entitled to a portion of the pension their spouse earned during their marriage. So what could happen is that you may have some expensive bills that you need to pay or other debts that you're carrying. And as soon as your former spouse turns 55, that share of the pension could help you pay those debts and take care of those bills that you have. Alternatively, you could leave the pension in the plan until the spouse retires and then start collecting the pension at that time. And that would give you a greater pension. But you could start collecting it as early as 55. The second question, should they split their pensions equally? Now, I can't answer this question because this is a legal question. So the parties' lawyers will have to review all the property, including the pensions, and hopefully come to an agreement regarding what's fair. They should consult an actuary for advice, as it may not be necessary to divide both parties' benefits. It may make sense to take both interests into account, but divide only one party's benefits. So the lawyers need to take a look at the situation and then work things out. I can't answer this question. So who are the professionals who can assist you? Well, for one, a certified financial planner can help you decide how to best use your retirement assets to produce lifetime income. Secondly, we've talked about this person a lot, a lawyer. And they can make sure that the arrangements for dividing the benefits are effective. And the third person is an actuary. An actuary can tell you how much the benefits are worth. And that's information that would be needed if you're taking the benefits into account in dividing other assets. So actuaries are very important to this process of dividing your pension and matrimonial assets. Now, the teacher's pension plan has specific information that they can provide to lawyers. The following documents are important for lawyers to use. And so if you have separated from your spouse or are going to separate from your spouse, your lawyer needs to have your person profile. That provides a complete history of the member's participation in the pension plan, which can be used by an actuary to determine the value of the pension. They also need to have the member's benefit statement. And that shows the active member's pensionable earnings, pensionable service, and contributory service. And if the member is retired, then the retiree's pension statement is a valuable piece of information for lawyers because it shows the retiree's selected pension option, any named beneficiaries, the amount of the monthly pension, and information about cost of living adjustment and bridge benefits. Okay, who do you need to contact? Well, first and foremost, the teacher's pension plan. So you can secure message them through the teacher's pension plan website and my account. or you can call them directly at 1-800-665-6770. If you need general information, general advice about pensions and what happens on relationship breakdowns, you can contact me at the BC Teachers Federation, slally@bctf.ca. You can also call me directly at 604-871-1949 or toll free at 1-800-663-9163, local 1949. So I hope you enjoyed this short mini seminar on the teacher's pension plan and relationship breakdowns and what happens in case you have a relationship breakdown and what you should do. Thanks for attending this session, and I look forward to presenting additional mini seminars to you. Thanks and have a great day. Bye-bye.